respondents'
So we'll say
argument
that
is
the
different.
instrument of accession did not result in a loss of sovereignty for whatever reason. Now, what are those reasons? Let's just formulate them.
I'm not going to the reason. I will only cite the judgment of this court.
All right.
That's AIR 1962 Supreme Court 1288.
AIR?
AIR 1962 Supreme Court 1288. That is Prem Kumar Deb's case. There's also in the Your Lordship's documentation, rather in this case for compilation. Right. Volume 6, I'm told,
Page?
number 10.
Volume 6 page?
Pages. Page 135.
135.
Yes.
This
Just have
is
a
the
look
case
at it.
dealing with the constitution of the Union Territory Cadre for Oneindia.
Yeah, there was some grant or something. What's important is that they go into this question when only instrument of accession is executed. That's all. No merger agreement, no supplementary agreement, nothing of that sort. What is its legal status? They categorically rule that the sovereignty will continue to vest in the ruler. This is what is in this judgment. Paragraph 11 of the judgment, well, also we see that. Paragraph 11 of the judgment. I'll have read it, but I don't want to waste time.
Yes, you have read it
told
already.
by my colleagues.
Yes, yes.
There's 11 expressly rules that. So on that basis, I'm saying, because earlier my lord's views were slightly different, in particular Justice Khanna's views were different. So I'm just citing the judgment, the constitutional bench decision, saying that the
You said 135.
paragraph 11,
PDF page 135.
PDF is what?
Which volume?
135.
Volume 6 said. Acha.
Volume 6.
Acha. Volume 6. Okay, I did volume 11.
Shah, these are
Not
just
PDF,
questions and
PDF.
queries. These are just questions and queries, just like you, this side, other side. These are just questions and queries, that's all.
No, my lord's asking me the question. I was just trying to respond to that. So my first proposition was that Maharaja retained his sovereignty. That's all I'm saying. Now, I also use the word, he retained residual sovereignty, if your lordship may recall.
Yes.
So residual sovereignty remained with him. Then what happened? After it was retained by the Maharaja, later on, at what stage it got transferred over to the people? It did not go into Article 1. It did not go into Article 370. That's what I'm trying to say. It has gone to the people. And it is in exercise of that residual sovereignty that the Constitution of Jammu and Kashmir was made. This is what I'm trying to say. It's incidentally meeting arguments of the respondents also that it was a concession, it was with our permission, so on and so
To
forth.
that extent, you're taking a different projection from others. There's a different argument as to what was argued by Mr. Sibal and others.
No, but on the question of sovereignty we are, I don't think there should be much. And it begins with the expression, we the people of state of Jammu and Kashmir. That should be enough to indicate that it is by itself an independent, separate constitution. But to say that this is inferior, to say it is subordinate society is something unpalatable to us, that we feel that this is our constitution, like people of India would feel proud that they have a constitution, which though in our case, we had proper elections, and then only we had representatives who made this constitution, unlike the Constitution of India, which was that no elections took place for forming Constituent Assembly. They were the representatives of various provinces. So we're on a better footing. Now, this constitution, which we made for ourselves, what did it do? In section 3, it said, now we are calling our constitution section, whereas that of Indian constitution as articles. This is also another thing which has slipped into our language. Actually, my constitution also has articles. This section 3, my lords, straightway stated that it shall be an integral part. That's the same position as taken in Article 1 or instrument of accession. That's there. But what's important is that when it says we will redefine our constitutional relationship, which was read in the morning, it is in the preamble itself. Now, what would exactly mean redefining constitutional relationships? What was the earlier constitutional relationship which we had, and it had to be redefined. It had to be enlarged or reduced or whatever was to be done. So we have two different entities, the Union of India and a federating unit. Between them, this was the mechanism in terms of which they would redefine their constitutional relationship from time to time.
Not redefined, further.
Define, further define constitutional relationship.
Yes.
This has happened from time to time. That's what the CEOs explain that from time to time, there was further defining of the constitution. Prior to that, what we had was only instrument of accession, and then 1950 order, then 52 order, then ultimately they got merged in 1954 order. Subsequent COs are all amendments made in 54 order. They are not independent by themselves. Why it was so? Because 54 order had been initiated by the Constituent Assembly itself. One of the issues which Mr. Subramanian also pointed out, I have a judgment, division by judgment of the High Court of Jammu and Kashmir, where they have gone into this question that it was initiated by the Constituent Assembly itself. That you also will see. This is in AIR 1971, Jammu and Kashmir, page 120. Justice First Lady has gone into this question. I will just read it quickly because we didn't have time to add to your lordship, so I'll just read it. So I did it for lordship convenience. Lordship may not have a copy of it.
Yes.
It simply says, I, Yuvraj, do hereby direct as follows. A Constituent Assembly consisting of representatives of the people elected on the basis of adult franchise shall be constituted forthwith for the purpose of framing a constitution for the Jammu and Kashmir. This was published in Government Gazette on 1st of May 1951. In obedience, this is court finding. In obedience to this proclamation, a Constituent Assembly was convened for the first time on 5th November 1951, as mentioned by petitioner para 13 of the amended petition. On 15th February 1954, the Constituent Assembly passed a resolution adopting the report of the drafting committee and the annexure thereto, and thus by doing so, the Assembly gave its concurrence to the application of certain provisions of the Constitution of India to the state in the manner indicated in the annexure. The resolution of the Constituent Assembly may be quoted thus. Then they quote that following Government of India. Now, this only leads to the conclusion that the process was initiated by the Constituent Assembly itself, forwarded to the Government of India. The President accepted this, and then 1954 extension order was passed. This gives the source, the history as to how this 54 order has come into existence.
Yeah.
After this comes into existence, then follow the later on, as many as in all, 54 constitution application orders have been passed. Out of them, this one is by the Constituent Assembly. Remaining others are by the government of the state. And those are in the nature of amending this constitution application order of 1954. Because they could not do it otherwise. This is another aspect you also need to consider. This was approved by Constituent Assembly. Others were not. So what they did was all these years, they have been amending that particular order. Now, sir, as a result of these constitution application orders, what happens is that which also found interesting, ocean of my constitutional autonomy was reduced to a pond by 4th of August 2019. Whatever it was just to call it, it's a skeleton. I would not like to call it, but we still had. Now, what was that fundamentally I had on that date? Broadly, I have given that in writing also broadly. I had my own permanent residence was one. I had the jobs reserved for the people who are permanent residents to only in the state government services. Number three, nobody could acquire the land. These were three fundamental things which I had as on that date. Then, of course, we consider it to be our identity. This 370 was in the nature of the identity of the people of state of Jammu and Kashmir, culturally and otherwise also. Linguistically also, different languages were spoken in Ladakh, Ladakhi, in Jammu, Dogra, in Kashmir, Kashmiri. So over these 70 years, a certain kind of interaction, mixing up of these languages, cultures had taken place, and it had evolved itself into a certain kind of a culture, which is a complete harmonious relationship between these three regions. This was the effect from time to time, and nobody questioned these CEOs also for all these years, that why are you shrinking our constitutional autonomy? And I had raised an argument last time also. I said that by conceding that the Parliament of India will have power of legislation over me, I was indirectly reducing the power of my own legislature, which otherwise it had. Name any act. I gave an example, there also TADA Act. My own legislature could have made it. But then this state cabinet recommended through the governor, you apply 97 in a specified manner, and we had Indian TADA Act applicable to us. Of course, that's the fate of the history as it is. But whatever was left, it was there as on 4th. Now, when you take this decision, what is to be done on now 4th? Somebody took the decision that we want to get rid of it. Why should we get rid of it? That I still don't understand. Why can't the Union of India accept there can be two constitutions? Why can't Union of India accept that it's a kind of a federation in which there can be two constitutions? There are examples all over the world where there can be two constitutions. It is not this solitary case in the world. Why can't that fact be accepted? Third, when you accept that you are an integral part of it, yet you have this constitutional autonomy between total integration, total merger, and some space between the state and them for historical reasons, not of its own, for historical reasons. That's an important part of it. So therefore, there were some problems, some circumstances, rightly said by respondents themselves, there were circumstances, situations in which it was felt by whom? By both the leaders of Union of India as well as the leaders of Jammu and Kashmir to provide this space for this autonomy to the people of the state. We're not going to the why this autonomy was given, but the fact of the constitutional position that this autonomy was given to us. And this autonomy could be taken, as all the councils have correctly stated, by concurrence, by consultation. You could take it away from us. We had to concede. We were on the giving side because it was with us. We had to donate. We had to surrender our power. The Union of India had not to do anything. It had promised only what was in the constitution. List 2 would apply to you, that is all. There was a promise not specifically to states of Jammu and Kashmir, but to all the states in India. That's how the constitution was framed. But so far as our constitution is concerned, we had to donate from time to time this power to Union of India. So both had to agree. Now take a look at 370 by and large. I'm not reading because time is less. Because 370 talked of three things. One, you need consultation, concurrence, and recommendation. 3 words are used. This is one side. 2, who are the institutions involved? You have the President of India, you have the government of the state, and Constituent Assembly. 3. All the provisions should also, so only 3 authorities are involved. But this government of the state is further requiring, in terms of the explanation, that it means a person who is recognized President of India, who has aid and advice of the Council of India. I lay emphasis on this, that this is a mandatory, indispensable part of Article 370 that you have to have in all situations. 356 or no 356. You need to have aid and advice of the Council of Ministers. You cannot make any CO without the consultation, without the concurrence of the Council of Ministers. I'm laying emphasis on that part. Yes, sometime back there have been out of 54 constitutional application orders, there were about 6 of them which were passed when state was under governor's rule or president's rule. But our stand on that, they were questioned. Before this court, I am told that some writ petition is pending. They were questioned, Jammu Kashmir High Court, the things remain. People did question them. Of course, they did not reach the logical conclusions. But at the same time, I must say that if they are unconstitutional, they can be questioned at any point of time. Law of laches does not apply to when the statute is unconstitutional or any action is unconstitutional. So even today, when we see this constitutional application of 2019, and we are questioning that, so we are free to question that on the basis that it was done without Council of Ministers being in place. This is the crux of our argument in this case. That's why I said earlier that let us go to the fundamentals. That the fundamentals in this case are this. Number one, that for this kind of change, which was made, it is not relatable instrument of accession, therefore consultation was not required. Concurrence was required. It is a mandatory requirement of 370, number one. Number two, the definition of the government given only for purposes of 370. I must make little digression here. We have government of the state under the Constitution of Jammu and Kashmir. And we have a far better provision there. That is section 35, which says, sir, that the governor will act only, the word used is only, on the advice of the Council of Ministers, which was not, you also will not find it in the Constitution of India at all. That way, how better our Constitution is. What your lordship is ruled by judicial decision, that the advice of the Council of Ministers is binding on the president. Our Constitution already way back in 1957 contained this provision that it should only act on the aid and advice of the Council of Ministers. Now, what do? So it means that the governor could not act without aid and advice of Council of Ministers in our Constitution. And here in this case, the governor acts. Fundamentally, apart from the other jurisprudential basis of the submission which have been made very at a different level, fundamentally, could they do that? Could the governor at that point of time do that? Now see more additional reasons. At that point of time, I was under 356 President's rule. What is its effect? Leave the 356, or what does it contain 357? My legislature is not my own, it is taken over by Parliament. My governor is not my own, his powers are taken over by the president. My government of the state is not my own, it is taken over by the president. All this is taken over by the president. Then in terms of 370, who gives concurrence? And who accepts that concurrence? We have a judgment of this court saying that when 356 is there, the powers are taken over by the president. How does he act? The president will act on the basis of the advice of the Council of Ministers, and this Council of Ministers is like the cabinet of the state government. If this be the correct legal position, it all means all is rolled into one, that is President of India. So it violates on the face of it the text, the requirement of Article 370. Forget for the time being, of course, without prejudice to what brilliant arguments have already been made, without prejudice to them. How could the President of India, when 356 is in operation, act on the advice on the recommendation made by Governor of Jammu and Kashmir, which governor had the status only, some, your lordship, some decision describe him as an agent of the president during 356, or some judgment to say that he acts as the president. In either of the situation, he is not the governor who has aid and advice. So for purpose of 370 and for purpose of other functions of the government, I respectfully submit there is a difference between the two. Specifically for 370, you need Council of Ministers. I'm not able to conceive of a situation where there cannot be Council of Ministers. That's the third thing. And the fourth thing, which is very important, is this, that you have applied 367 and modified it and applied it. Now, for the consideration of my Lord Justice Khanna in particular, my lords have been observing. What do you think of 3(1)(d), where you apply constitutional provision with modifications and exceptions? I'm saying something else. You first applied 367 by virtue of 3(1)(d). You applied that to which provision? You applied that to subclause 3 of 370. Subclause 3 says, notwithstanding anything contained here in above. The question which immediately falls for consideration is if you have carried out a modification in terms of 3(1)(d), but applied that modification to subclause 3, when the 3 says notwithstanding anything contained here and above, isn't that 367 modification excluded from application to subclause 3 of 370? I'll consider this aspect of the matter. And it says notwithstanding anything above would mean also any constitutional application order issued under 3(1)(d) will also not apply when you want to act under subclause 3 of 370. So therefore, on that basis also it has to be faulted. So therefore, I'm submitting is going by the basic premise, the basic principles. That this action of 272, it does two things. Best part, then the last thing which I want to submit to Lordship consideration is one more thing. This power of concurrence. I say, for your Lordship's consideration once again, in 1957, we adopted our own constitution. Prior to that, we had Constituent Assembly. As rightly said, Constituent Assembly can do, undo things because it is not subject to any fetter. There is no control on a Constituent Assembly because it's free to evolve and deal with its affairs. But after the Constitution was adopted on 17 November 1956, I'm submitting this. The state government comes into existence under the Constitution of Jammu and Kashmir. But at the same time, the state government is required to give its concurrence or consent under 370. I say my constitution, Jammu and Kashmir constitution, is in the nature of a limitation on the power to give concurrence after 1957. Meaning thereby, even if there was Council of Ministers in place as on today, they also could not give any concurrence because it is subject to the limitations of the Constitution of Jammu and Kashmir. Now, what are those limitations? On the prima facie, I will show. If you also will have a look at 272. The first part says the Constitution of India as amended from time to time shall apply, subject to the modification as follows, that is 367. Means the entire Constitution is made applicable on the so-called invalid unconstitutional concurrence of the governor. When you do that, you are contradicting Constitution of the state. And when you are contradicting Constitution of the state, there is a limitation in your power of giving concurrence under the Constitution of the state. Meaning thereby further that our Constitution had to stay. It had to permanently stay because the state government no longer could give its concurrence in contravention of the provisions of the Constitution of the state. That limitation will have to be read into this power of concurrence after 57. Of course, there will be provisions which don't come into conflict. For example, take the High Court. Somebody cites the example of the High Court. Now it is established under my Constitution. When you say somebody gives concurrence, the Article 215 of the Constitution of India will apply. It comes directly to conflict with my Constitution. The question is not that is superior, I am inferior. No, the question is, did I have the power to give the concurrence for the application of 215 or any other provision of the Constitution of India? My submitted lordship says I am controlled in my concurrences now. I am controlled in my consultation is something different that relates to instrument of accession. But in respect of application of these constitutional application order, I am controlled today by the Constitution of Jammu and Kashmir. So therefore, on that second ground, also I say that this 272 as well as 273 are both are constitutionally absolutely invalid. Now, my lords, observe that, okay, you are still in history, let us progress further. Isn't this COs issued 54 in number from time to time? Isn't no, it was not a step in right direction. I put it to myself. It was getting closer and closer. What made you to do it on 5th August? It is not still forthcoming. And there is something more to it also. You also may recall, I said, when this concurrence is given by the government, this Governor Jammu and Kashmir as stated in the text of 272 order. When was that concurrence given? Who gave that concurrence? What was the nature of concurrence? No material that is concealed from this court. No material is produced before the court. It is not in their affidavits. Despite having been stated in the petition that, look here, we want to know who gave this concurrence. What is the date of that concurrence? Who signed that concurrence? Was it done one day before? Was it done 10 years before? Who gave that concurrence? We are entitled to know it. This court is entitled to know it. There is no material on that basis. So therefore, that apart. But further than somebody says that we have given the concurrence, it doesn't look legitimate. It doesn't look sustainable. It looks all against the Constitution itself. Then lastly, I would like to submit, many statements were made here. Insofar as the development is concerned, I have only one thing to say to our learned friend, Solicitor General of India. They say self-governance is better than good governance. That's all I can tell him. Give us our self-governance back. That's number one. Number two, somebody also said it here, it is very important. Nation has to grow. We can't waste our time. We want to have a unified nation. Of course, very noble thought, very good thought. But then for that, you have to win over the hearts of the people. You cannot form a nation by force, by compulsion. Win the hearts of the people. If your lordship decides this matter in favor of the petitioners, your lordship will be going a long way in winning over the hearts of the people of Jammu and Kashmir. That's all I would thank.
Thank you, Mr. Zakshan. Dr. Dana?
Just a minute, just a minute. Just last thing, Milord, only last say that. What initially we were promised, I just look at it from another perspective, and the people who like to know that. What initially was promised was we'll put in sort accession to a referendum. It was not done. They told us, not people of Jammu and Kashmir. It was Governor General's letter. They took the matter to United Nations. They said, go for plebiscite. It is not done. Now, after that, this constitutional autonomy was left all these years. But in 2019, that is also taken away. Who has lived up to his commitment? The great leaders of India, Jawaharlal Nehru and Patel, they were statesmen. They were not politicians. They made these commitments to the people of the state of Jammu and Kashmir. It is in parliamentary debates. It is outside the parliament. It is everywhere. But now today, since there are no statesmen left, we have politicians. Decisions have been taken. People feel betrayed. That's all I can say. Thank you.
Yes, Dr.
Lord, I have five arguments. That's just fight way away. He sent messages from me. Go ahead of me. Somebody. May please. My Lord, I have five submissions to make. The first is relates to the temporality of Article 370 and its interpretation. And how it impacts on CO 272 and 273. My second related proposition is that mandatory provisions of the Constitution are not defeasible and cannot be derogated from. The third is, my lord, the basic structure argument, which has two aspects, my lord. Firstly, basic structure is a constitutional limitation. This is not the argument we wish to advance. That is, if there is an amendment, basic structure will apply. That's the constitutional limitation. What we emphasize is basic structure as a principle to be applied by all authorities and especially the courts. The fourth, my lord, argument is the location of sovereignty and the constituent power
Location of sovereignty in the constituent power.
No, my lord, the location of the substitution of a statehood, my lord.
Sorry, the fourth one,
Sorry, my lord.
how did you begin the fourth proposition? I perhaps didn't take it correctly.
The sovereignty proposition, my lord.
Yes, how do you begin? Did you say location of sovereignty or?
My lord, I'll explain that when I
No,
come
but
to
just as a head, what would you like us to take?
Broadly speaking, my lord, the argument is this, that generic basic sovereignty lies with the people. To operate this, there is sovereignty which is external in nature in terms of international law. That is, no other state can make you a vassal state or has any power over you. And the third, my lord, is after the Constitution has been enacted, where does the constituent power lie? On which Mr. Dwivedi had a few things to say. And the fifth argument, my lord, is the substitution of statehood by union territory, on which I want to cite just one section of the Reorganization Act. What I propose to do, my lord, is this, that as far as the citations I want to give, I put them on a piece of paper. I think they've been uploaded. I'll hand it over to your lordships, so that your lordships doesn't have to scribble. I think you've done enough scribbling for quite some time. So, my lord, let's come to the first question of temporality. We've done our share of scribbling too, my lord. Let's come to the question of temporality, because that goes to the real issue before your court, lordship's court. What does temporary mean in 370? The Chief Justice pointed out that when you contrast it with 269, where it says 5 years, therefore certain conditionalities have to be met. If those conditionalities are met, then at that particular point in time, the temporariness goes. Now, what were the conditionalities, my lord, that were available as far as 370 is concerned? There were two two sets of powers in 370, which were assigned to the Constituent Assembly. The first power was to reject the constitution-making process completely. That is 370 subclause 3. This is a power that the Constituent Assembly did not exercise. CO 44. CO 44, my lord, where this power was used. It did not exercise this power to abrogate the constitution process completely. The second, my lord, conditionality was to fulfill its task of making a constitution. This task was fulfilled in 1956 and came into effect on the 26th of January, 1957. So both temporalities, my lord, exhausted themselves in 1957. After that, my lord, 370 ceases to be a temporary provision. I'm not saying cease, which has been argued on this side by one council, that it ceases to exist. I'm saying it ceases to be a temporary provision. In my respectful submission, what follows is that it becomes a special provision of the Constitution, like 371A, all the schedules, etc. So 370 would be read, my lord, as a special provision, just like the other special provisions that you find in 371A onwards. Or the many provisions that you find giving autonomy in the 6th schedule, which is such a vast schedule of autonomy, because by this time, autonomy was attained by the JK Constitution. Now, my lord, there was what kind of federalism is this, my lord? It's an example of cooperative federalism. Where two powerful democratic forces meet and decide on the fate of a particular area of the Constitution. One powerful democratic force came from the people of Jammu and Kashmir themselves in the antecedent discussions, as well as through the Constituent Assembly. That is, a powerful democratic movement had to be taken into account. The second, my lord, is democracy had to be preserved as part of cooperative federalism. Hence, to make it a balanced cooperative federalism, we find the words concurrence, consultation, recommend. These are methods of cooperation in a cooperative federalism. And they're writ large in the 6th schedule as well, my lord. I've taken your lordship through that. I won't do it again. Now, my lord, the argument on the other side is that it remained temporary for 60 odd years. Lord, that argument is almost a farce. if a constitution has continued for such a long period of time and been used as such for a long period of time, you can't say it remains a temporary provision. What is left of 370 is just 370 subclause 1. Because 370 subclause 2 and subclause 3 are dependent on interaction with the Constituent Assembly. This is a mandatory provision which is indefeasible. Therefore, my lord, when I say a special provision survives, my lord, in the spirit of cooperative federalism, it is 370 subclause 1. The rest, my lord, because the Constituent Assembly has completed both its tasks or conditionalities, one in not going the non-constitutional route or going the constitutional route as the case may be, nothing survives in 370 subclause 2 and 3. Nor is it possible in 370 subclause 3 to argue a doctrine of substitutability. That for Constituent Assembly, you can substitute legislature. Nor, and on that I'll give a note on what the proviso says, my lord. The proviso, my lord, has a symbiotic relationship with the main provision of 270 subclause 3. Now, some arguments were made, my lord, and I must, because I don't know whether they were made frivolously, that 370 is a compromise. If, my lord, 370 is a compromise, you'll find compromises right throughout the Constitution. Take, for example, Article 25. Sikhs are allowed to carry their daggers. You want to get rid of that, my lord? You have to have a constitutional amendment. This is a compromise. The entire 6th schedule is a compromise. But the most important compromise of all concern the privy verses. It's a compromise between 271 and 362. They said, all right, you've surrendered everything. By way of compromise, we give you a privy purse. And what do the two judgments, my lord, on these two say? Madhav Rao Scindia is clear, along with the other judgment, to say, if you want to take this compromise away, then you must amend the Constitution. Therefore, any compromises that are there in the Constitution, my lord, follows from a very important insight, my lord, of Ali Nariman's, that if today we were asked to make a constitution, we would not succeed. It's in one book of mine published 2 years ago, but that's a different matter. Israel was never able to come to terms with getting constitution through because it could not evolve a compromise anywhere. New Zealand did not initially have a constitution of its own. It couldn't come to terms. So as far as compromises are concerned, they are writ large across. That is the process of constitution making, to accommodate the largest number of views and come to a compromise. And that is borne out, my lord, by the princely persons cases. That was a compromise. We'll give you your princely purse. And when they tried to change it by definition, Madhav Rao Scindia, the first Madhav Rao Scindia, my lord, said, sorry, by definition, you cannot change it. This is, in fact, a compromise which is embedded in the Constitution 271 and 362. It is only after the amendment was made that the compromise was set aside as a part of the constituent power. Now, my lord, I want to test this particular argument. One argument has been made, my lord, with the second argument that I want to advance is non-derogability of mandatory provisions. And then we will test this against 272 and 273. There is no doctrine of necessity in our constitution, my lord. There is a doctrine of constitutionality, but no independent doctrine of necessity. It is about the most dangerous addition that one can make to any constitutional process, where you say, because of necessity, we could not follow your mandatory provisions. Your lordships have held that even directory provisions must be complied with to the extent possible, but we're not there now. We're on the question of mandatory provisions. Now, as far as 272 and 273 are concerned, my lord, one argument that I want to enlarge on the basis of what Mr. Gopal Subramanian said, my lord, kindly have a look at 152. This, I won't give the dates again because these dates have been given by Mr. Subramanian. In this part, unless the context otherwise requires, the expression state does not include the state of Jammu and Kashmir. Therefore, as far as the entire part is concerned, this constitution recognized the relevant provisions relating to the states, legislature and otherwise, my lord, and incorporated those provisions after, my lord, 238, etc., was done away with, as my lord, the Chief Justice pointed out. Otherwise, there would have been a vacuum. How was that vacuum filled? By reference to the JK Constitution and those relevant parts of the JK Constitution itself. Then, my lord, if your lordships will kindly come to 308. (308), my lord, is part 14 of the Constitution, which deals with services under the Union and states. All this, of course, has been done away with, my lord, now, without amendment by the Reorganization Act. It says in this part, unless the context otherwise requires, the expression state does not include the state of Jammu and Kashmir. This, my lord, would be a vacuum, but for the fact that the constitution makers were aware that provisions relating to these two parts relating to 152 and 308, were already there in the Jammu and Kashmir Constitution, and in fact, as far as these are concerned, they were incorporated by implication into the Indian Constitution. Now, my lord, on the basis of this, let us just test 272 and 273. My lord, there's another aspect, my lord, and our small argument was made that the preamble doesn't contain socialism and secularism. It's actually there in the Jammu and Kashmir Constitution. I'll just give your lordships the sections. No, just give me my black volume. First, my lord, kindly come to section 13. This is volume 2, PDF 20. I'll just read it out, my lord. There's no point, your lordship. Otherwise, I'll dream of PDFs all my life, my lord. I don't want to do that. Now, my lord, 13 says, state to establish a socialist order of society for the promotion and welfare of the people. Long before it came into the Indian Constitution, what was the necessity of amending the preamble? Then, my lord, if your lordships would kindly come to section 20, compulsory education. The JK Constitution says compulsory education in certain cases and reflects those educational provisions in the directive principles. And the third, my lord, is section 25, the state of duty of the state to foster equality and secularism. So it was no great omission, my lord, as far as the JK Constitution was concerned, as has been pointed out. Now, my lord, let us come to (272) and 273. Bearing in mind that mandatory provisions of the Constitution are not defeasible. My second proposition. Now, my lord, one thing that I forgot to mention when I mentioned 152 and 309 of the Constitution that says it shall not apply to Jammu and Kashmir is it was done by this amendment of the Constitution in the 7th Amendment. Therefore, if any change had to be made, it could only have been done by the constitutional amendment and not otherwise. With this, let me read, my lord, CO 273 first. None of the conditionalities of 3C70 and subclause 1 are met here. It says, in exercise of the powers of clause 3 of the President of India on the recommendation of Parliament. Where does Parliament come in, my lord? The body in question, according to the original Constitution, is Constituent Assembly, and according to 272 is the Legislative Assembly. Where is the question of Parliament coming in as a double substitution, which is there in 272 and 273? But let me just read on. All provisions of the Constitution, as amended from time to time, without modification or exception, shall apply to the Jammu, notwithstanding anything contrary to Article 152 and 308. Those are the provisions, my lord, where the Constitution, 7th Amendment, said that these provisions will not apply to Jammu and Kashmir. Is it possible, my lord, within an exercise of power under 370, to amend provisions of the Constitution or not? Because this was the stumbling block, my lord, in their way. The answer is they have not, my lord. Of course, as far as the conditionalities are concerned, none of them are met. There is neither concurrence, nor consultation, nor recommendation. It just says on the recommendation of Parliament. Where does Parliament come into this? Therefore, my lord, 273 is an amending provision well beyond the scope of Article 370. And not only is it amending, my lord, it also goes further to destroy any other article of the Constitution or any provision of the Constitution of Jammu and Kashmir, any law, document, judgment, ordinance, order by law, rule, regulation, notification, custom, usage, having the force of law in the territory, or any other instrument. Well, this is an amendment and actually an abrogation of 370 itself. That power having gone, if we agree that 373 has gone because the Constituent Assembly cannot be substituted. So the argument that Mr. Sibbal made and was just made by Mr. Zafar Shah is there are two entities here. Two entities who are part of cooperative federalism. They have to interact. And the interaction is there in Article 370 and is entirely and totally missing from 273. If 273 falls, my lord, there will be a revival of 152 and 308. There has to be, because they are not, you cannot amend the Constitution which has actually been amended by the 7th Amendment. Now let's come to 272. This begins, my lord, by saying, in the exercise of power under clause 1, bear in mind, my lord, the exercise in 273 is under 373, which in our view has actually disappeared. Now I'm going to show its reappearance in another form. In exercise of the powers under clause 1 of 370, the President, with the concurrence of the government of Jammu and Kashmir, is pleased to admit. Now, my lord, if your lordship were to see the main provision of 367, subclause C says, references to the government of the state shall be constituted as including references to the governor of Jammu and Kashmir acting on the advice of the Council of Ministers. Therefore, my lord, when they say in concurrence with the government of the state, it has to be on the basis of the advice of the Council of Ministers. Therefore, there is a contradiction here between the interpretation clause and the opening clause of 272. This too is draconian because all the provisions, my lord, which are relatable, it just wipes them out completely without following any mandatory procedure. Now, what is the saving grace, my lord, that is provided here? And that is indeed in the proviso of clause 3, Article 70 of the Constitution, the expression Constituent Assembly referred to in clause 2 shall be read as Legislative Assembly. Here there is a double substitution according to them. Firstly, the Constituent Assembly is replaced by the Legislative Assembly. They're not on par, my lord. They're simply not on par. The Legislative Assembly, this idea that both had legislative and concurrent powers, constitutive powers, that is true of the Constituent Assembly of the Indian Constitution. There's a whole set of debates dealing with the legislative powers. As also, my lord, of the Jammu and Kashmir Constitution. So can such a substitution take place? Now comes the double substitution which we see in 273. Instead of the Legislative Assembly of the state, we get Parliament. So these provisions now involve a double substitution contrary to 373, contrary to 272, and we now move from the provisions, my lord, of recommendation under 370, concurrence, which is of course completely missing, my lord. Mr. Zafar Shah has pointed this out. I don't want to elaborate it. Totally and completely missing. The arena of cooperative federalism is entirely and totally missing. But can you have a double constitution substitution in this way, my lord? And that is to say that 367, the added clause is that the references to the government of the state shall be construed as references including the governor of Jammu and Kashmir acting on the advice of the Council of Ministers. This is what the new interpretation is. You didn't act on the advice of anybody. You just said here that concurrence of the government of the state. Now, according to 367 itself, it means with the Council of Ministers. That is a mandatory provision. So, my lord, 272 and 273 are overbroad in violation of mandatory provisions of the Constitution. And shift the entire concurrence or consultation provisions or recommendation provisions from the authorities of Jammu and Kashmir to Parliament. This is the double substitution argument that they have advanced. Now, my lord, we come to the interesting part, my lord, of Article 3. Article 3 has a mandatory provision. I put that in my original submission, my lord, from 1960 onwards, that you must circulate any bill or change on the reorganization of, you must circulate it to that legislature. This is a mandatory provision. It is true that your lordships have also held, and those references are there in my original submission, that the centre is not bound by all your recommendations and subsequent changes can take place. But this does not take away from the fact that Article 3 is a mandatory provision. Now they say, as far as this is concerned, under Article 356, there is a power, my lord, to make incidental provisions that are necessary and desirable. And they say that one of the provisions that was made was that Article 3 will not apply. That is in not the President's proclamation of 19th December. Effectively, that's what it says. These provisions will not apply. It can't be done, my lord. President's rule, under President's rule, you do not have the power to do away with a mandatory provision of the Constitution. Now, my lords, I want to point out one thing, my lord, to your lordships, if I may. About the Reorganization Act, my lord. I just want to read one provision to your lordships, my lord. And that is Section 73. This is, my lord, Volume 3, PDF 112 at 130. I'll read it out, my lord.
Just repeat that, Mr. Now.
Volume 3, 12 and 130.
Volume 3, PDF 112, where it starts, my lord.
Documents, what?
The Reorganization Act. And I'm reading Section 73, which is at PDF 130. If the President, on a receipt from the Lieutenant Governor of the Union Territory of Jammu and Kashmir or otherwise, is satisfied that a situation has arisen in which the administration of the Union Territory cannot be carried out in accordance with the provisions of the Constitution. That is the same as 356. Now look at the next clause. That for the proper administration of Union Territory of Jammu and Kashmir, it is necessary or expedient to do so. This is also, my lord, there in Article 239A, B. So we've added one more section to it, that if you think it is not expedient, the president may suspend all operations. The more important thing in section 73 is it has no time clause. So today, my lord, when your lordship asks for a roadmap, today the Constitution, my lord, that the president's rule that survives is under section 73. Unlimited time when it is expedient and necessary to do so. Necessary or expedient to do so. Lord, this is the core of the problem when your lordship asks for a roadmap. They are unable to give one. They too are, in a sense, are arguing that the Reorganization Act is in fact transitional in nature. A time will come when statehood will be restored. This is no roadmap at all, my lord. It is entirely and totally illusory. What is not illusory is the continuance of president's rule under section 73. This goes to the core of the governance, my lord, and the relationship of cooperative federalism. I want to make one more further point, my lord, on mandatory provisions. Although, my lord, there are several occasions when 370 has been used under president's rule, I'm going to make the broad argument, my lord, whether it was challenged or not is irrelevant, that when there is president's rule and cooperative federalism under Article 370 cannot apply, then 370 cannot be used at all. Because the mandatory provisions, my lord, require concurrence, consultation, recommendation. If these are absent and president rule, because of some suspensive order, gets rid of it, my lord, in no president's rule can be applied, my lord, 370. Because the very foundation of 370 would disappear by an exercise of a CO. So these are my first two propositions, my lord. Now I go to the third one. I'll have something to say in the proviso, my lord. What I've done is I've called out the authorities that I want to rely on, which I'll hand over, rather than your lordships will not be troubled. And that is, my lord, relates to the basic structure doctrine. It is not the case of anybody that the basic structure doctrine applies in this case as a constitutional limitation. Nobody has argued that, my lord, and it cannot be so. But what the basic structure doctrine has been applied as is as a principle of the Constitution. Now in Nagaraj, my lord, and I'll point out those two paragraphs. This is volume 19. PDF 164 at PDF 195. And kindly bear in mind, my lord, that in Bomai there was no constitutional amendment involved. And there are many provisions of that nature. There the principle, my lord, of the basic structure was applied. It is our respectful view that if democracy, federalism, reasonableness is given the go-by, then it would follow, my lord, the principles of these underlying these basic structure formulations will necessarily, my lord, guide your lordships in the exercise of any constitutional power. Now, my lord, I'm just going to read two passages from Nagaraj. I've given your lordships, my lord. The citation is 2006 8 SCC 212, which your lordships will find in volume 19, PDF 164 at 195. Has your lordship got that one? Para 24. The point which is important to be noted is that the principles of federalism, socialism, secularism, and kindly bear one more thing in mind, reasonableness and socialism are beyond the words of any particular provision. They are systematic and structural principles underlying and connecting various provisions of the Constitution. They give coherence to the Constitution. They make the Constitution an organic whole. They are part of the constitutional law, even if they are not expressly stated in the form of rules. Now, in Nagaraj, they defended the constitutional amendments, but subject to certain conditionalities that were imposed. And they said the identity of equality is not taken away, but you will follow these guidelines. Now, my lord, kindly come to the bottom of that page, that is para 26, next to placetum G. Overarching and informing of these rights and values is a principle of human dignity under German basic law. Similarly, secularism is a principle which is an overarching principle of several rights and values under the Indian Constitution. Therefore, axioms like secularism, democracy, reasonableness has been elevated to a part of the basic structure. Apply that to 272 and 273, my lord, and the answer will become clear. Social justice are overarching principles which provide linking factors for the principle of fundamental rights. These principles are beyond the amending power. They pervade all enacting laws, and they stand at the pinnacle of the hierarchy of constitutional values. It is our case, my lord, that the basic structure applies not as a constitutional limitation, but as a set of overarching principles which are part of the Constitution. Now I get back to my argument, my lord. It is idle to say that when my lord the Chief Justice used the word asymmetric, it was used in any casual sense. That is NCT 2. I said that it is a multi-symmetrical constitution, which I've shown to your lordships. And there is a violation of the multi-symmetric provisions of the Constitution as far as this exercise of 272, 273, and 370 is concerned. Otherwise, my lord, the whole Constitution would become meaningless. Bomai is a classic example, my lord, of where there is no amendment whatsoever, but you apply the principles. And there, of course, there are a host of others. Therefore, my respectful submission to your lordships, my lord, is basic structure is a statement of principle applies in this particular case, though not as a constitutional limitation. Because I'm equally allergic, my lord, to the idea of going beyond the amendment process as far as constitutional limitation is concerned. I'm allergic to that particular idea. Constitutional limitations have their limitations in 368, provided there is an amendment. But there are also principles that are violated, and to that they have not provided any answer. Now I'm on the question of sovereignty, my lord. More to be said. Now, my lord, I come to the question of the location of sovereignty in the Indian Constitution. Now, my lord, sovereignty has one meaning in international law. That is, you are not under any other country. To that extent, my lord, there is, as my Lord Justice Khanna pointed out, across the board, nobody has argued that the Indian Constitution is not sovereign and that Article 1 does not apply across the board. That is nobody's case. But I'd earlier made a distinction between external sovereignty
And internal sovereignty.
and, my lord, internal sovereignty. Now, I think internal sovereignty, my lord, is a bit of a misnomer. It really means the application of sovereignty in the distribution of powers. I'm amending that to that extent. Therefore, my lord, how is sovereignty to be exercised is what one means by internal sovereignty. It's the exercise of sovereignty distributed throughout the Constitution. Mr. Dwivedi has made some arguments, my lord, that there are many provisions of the Constitution that says this will not be an amendment to the Constitution. I've got, my lord, passages from Keshavanand. They were aware of these provisions, and they regarded this provision simply to mean you don't have to follow the procedure of 368 and nothing more than that. The constitutive power, sovereign power, exists in 368 and in no other provision of the Constitution. Otherwise, we'll be saying, my lord, that when the Constitution is, that you can amend the Constitution for the next 2 years, that during that interregnum, it's a constitutive power. And finally, my lord, I come to my last point, my lord, which is the substitution of statehood by union territory. My lord, the Constitution actually divides itself into two halves. A federation of states is one part of it. And the second part of it, my lord, are what could be called devolutionary provisions. That is union territories. Now, England, for example, my lord, Northern Ireland, my lord, has a lot to do with that since I taught there at Queen's, is a devolved provision. Wales is a devolution provision, so is Scotland. Whether they will be removed or not, my lord, is within the gift of the supreme power of Parliament. That is a different matter altogether. What has happened is that statehood has been taken away completely. Therefore, as part of the federation, union territories are not part of the federation of states. They are devolutionary units which can always be taken away. And that is a fundamental distinction, my lord, recognized in all constitutional jurisprudence between, my lord, a federation and a devolutionary power. Now, my lord, I'll just hand over that note to your lordships, if I may. I think it's been put up as well. Just give me one copy. So that your lordship doesn't have to take down references, etc. My lord, the first is in relation. Has it been handed over, my lord? I think it's been uploaded as well. Huh? As a note on rejoinder, my lord. On proviso, my lord, the classic description of a proviso was given by Justice Fazazali in Sundaram Pillai. We need not multiply authorities after authorities on this point.
That part, it's a classical judgment on, it's a classical judgment.
That's right, my lord. But what it says, it may entirely change the very intendment of the instance by insisting on certain mandatory conditions. In order to make it workable. Now this, my lord, Mr. Gopal Shankar Narayan tells me, has been approved in Manohar Lal's case. Your lordship may just note that, my lord. Constitution Bench 220, 8 SCC 129 at para 193. At para 193.
Need the citation, please?
Over the page, my lord, I won't take your lordship's 2020 Constitution Bench. Your lordship is familiar with these provisions, my lord. That's why I don't want to read all of it. And over the page, my lord, I've given two further examples of the proviso as a condition precedent. That is, Edwinson, State of Assam, where consultations had to be taken with the board, or Narayan Das, my lord, where consultations had to be taken. And this is a condition precedent. Now I come to, my lord, on the application of the basic structure doctrine as a principle of interpretation of the Constitution. Bomai, my lord, is my first example. I've given your lordships the paragraphs and the PDFs. In Kolo, my lord, and across the board, use was made of basic structure as a set of principles. Once again, I've given that at 3.2. As regards interpreting 301 and 304 Jindal, the government of NCT versus Union of India, my lord, while interpreting the proviso to 239 AA4, and over the page I've reproduced from the second NCT judgment, my lord, because it's in my written submission, but I just reproduced that paragraph. I don't need to read it. These are all principles that have been applied across the board in interpreting statutes as well, and in certainly as far as constitutional provisions are concerned. Now, my lord, the argument that was advanced was that there are other provisions that by Mr. Rakesh Trivedi, which say this will not be deemed to be an amendment of the Constitution. In Keshwan, my lord, the lordships were aware of this. For example, Justice Hegde and Mukherjee, amendments under 4, 169, 7 of the 5th schedule, para 21 of the 6th schedule, need not comply in the form and manner prescribed under Article 368. So, my lord, it is not that they are a part of the constituent power. They need not comply with the provisions of 368. The same, my lord, is for Justice Palekar, who once again notes these provisions. I won't read that, my lord, because the point is there. Then Justice Matthew, my lord, who says enactments under 4.169, para 7, 5th schedule, para 21, are effected by ordinary lawmaking procedure, which is different from the procedure under Article 368. They're not rigid, they're not ancillary constitutional power. They are, in fact, special provisions which don't require the invocation of 368. And then, my lord, there is Justice Beg and Justice Chandrachud. My lord, that's all I have to say. Now, my lord, what is the reliefs that we are seeking? If we stay within, my lord, a very narrow circle, then Mr. Sibal is right. All your lordships have to adjudicate is the temporality of 370, 272, CO 272, 273, and whether mandatory provisions are defeasible. That is all that is before your lordships. The antecedent speeches, so many have been quoted, my lord, in the list of dates, are totally and completely irrelevant. Because as soon as 370 is born, that is the provision which is the incorporating provision, and there is no other. You don't even have to refer to Gopal Swami Iyengar's provisions.
Thank you, Mr. Lal.
I'm obliged.
Thank you, Dr. Lal.
May it please the Lord. Lord, whichever way your lordships were to look at this, Lord, democracy, federalism, rule of law, Lord, constitutionalism, each one of them is a basic structure of the Constitution as has been held by your lordships. Every one of those principles of Lord, basic structure are not completely thrown out of window by exercise of this power by the president. Now, Lord, there are three broad arguments which have been raised on behalf of the government of India. One, that Article 370 is temporary. Two, that presidential exercise under sub-article 3 of Article 370 is a valid exercise. And three, of course, that the state reorganization is a valid piece of legislation. Now, Lord, let me begin by, Lord, pointing out that, Lord, in Coelho, your lordships have expressly now said, Lord, para 137, just kindly make a note, I'm not going to trouble your lordships taking to the paragraphs. Para 137, Lord, quoting Sirvai, that there are two powers which are fiercely independent. One is the constituent power, which is a plenary power. The other is a power of amendment of the Constitution, which is a derivative power of the plenary power. So power of amendment is always not conferred by the constitutional framers, and that power must be exercised within the four corners of the Constitution. We have now a third situation where there is a constitutional power to be exercised by the President of India. Now, my Lord, first and foremost, as your lordships have brilliantly put it time and again, nobody is imperium in imperio under our Constitution. Lord Digvijay Mote is a judgment where your lordships very brilliantly, Lord, put this. 1993, 4 Supreme Court cases 175. 1993, 4 SCC 175. No one is an imperium in imperio in our constitutional order. It's reasonable to hold that the election commissioner cannot defy the law armed by Article 324. Now, can President defy Article 370 merely because he has power under 370, which he assumes to have the power? Now, my lord, second principle that your lordships have brilliantly put beyond pale of doubt is that there is no unreviewable decision under our constitutional order. Every decision is subject to judicial review. Nothing is unreviewable. Parliamentary laws are subject to review. Executive orders are subject to review. Constitutional exercises are subject to review. And that's not where this democracy survives. Now, in fact, my lord, in Coelho, your lordships go a step further and say that merely by inserting the words constituent power in Article 368, the Parliament has no greater power than power of amendment. It's not an original constituent power. They may have used it, and that's why, my lord, in Minerva Mills, your lordship struck down sub-articles 4 and 5. Precisely for that reason. So, power of amendment, your lordships have consistently held, is subject to constitutional limitations. Now, how do we, therefore, my lord, look at this? My lord, your lordships have always said, and this is very, my lord, interesting, as Samant puts it, my lord, the duty of judicature is to act upon true intention of the constitutional framers, the Constituent Assembly. That means sententia legis. How do you gather that intention? Can you travel outside Article 370 as what the government would like your lordships to do? In my respectful submission, no. The entire basis of the arguments are circumstances prevailing today to justify this exercise and then to persuade your lordships that this is what Article 370 means and that's why it's temporary in nature. Now, my lord, don't take anything. 370. Lordships have said that Lord, your lordships have liberty to, Lord, interpret the constitution within permissible limits. Your lordships have always, Lord, upheld that principle very soundly. But the government wants your lordships to read something which, Lord, I find it very difficult to understand. On a plain reading and clear intention of the constitutional framers, Lord, these were men and women of extraordinary wisdom. They've worked for over 2 years to draft the constitution. But whatever their intention was, they have put it in this article. We don't need to travel outside at all to find out what that intention is. And that intention is in 371C. Please see 371C, don't turn to it. It says, provisions of Article 1 and of this article shall apply in relation to that state. So they have permanently embedded 370 into the constitution along with Article 1. Having embedded that, because it is through Lord 1C that 1A, B will come into play. Because they have now said 370 shall apply in relation to Jammu and Kashmir. Now, Lord, they were aware that Lord, they had some understanding with the state, where state wasn't sure whether it wanted to continue this association with us or not. So they therefore drafted sub-article 3 to say, notwithstanding anything in the foregoing provisions of this article, on the recommendation of the Constituent Assembly, I am paraphrasing it, on the recommendation of the Constituent Assembly of the state, President may, by public notification, declare that this article shall cease to be operative or shall be operative only with such exceptions. Now, my lord, can any other meaning be given to the expression Constituent Assembly? Contrary to what they had said, because that's also used in sub-article 2. Today, Lord, after 70 years, you might say, read Constituent Assembly to mean Legislative Assembly. And legislature to mean Parliament. Lord, I respectfully submit that this is the limiting provision. The temporary nature of the article is in sub-article 3. Because they wanted to give people of Jammu and Kashmir, through the Constituent Assembly, the right to decide whether they wanted to continue with India, whether they wanted to follow Constitution of India or not. Nothing more, nothing less. Otherwise, 370 is embedded into the Constitution. And it's not temporary, it's permanent. An exercise under sub-article 1 is therefore permanent exercise to be done from time to time. For principle of contemporaneous exposition. For 70 years, if government of India brought order after order after order, exercises powers under Article 370, but can it now lie in their mouth to say that Article 370 is temporary? That's how they've understood. That's how they've acted. Merely because government has changed of a new party, does it mean that it has suddenly become overnight temporary? This is something which I want your lordships to kindly appreciate, that 370 was never intended to be temporary in its heart and soul. Only temporary nature was to give the right to the Constituent Assembly to decide what do you want. If they had decided, no, we don't want it to continue, President could have issued the order. Instead, they said, no, we want to be part of India, we want Constitution to apply. But we want it to be applied in the sense of Article 371. And 2, essentially 1, consultation and concurrence. Is it not something extraordinary that is being done? It is not the case of Government of India that 370 has not worked over last 73 years. Not one example to show that 370 has failed. Every time the Government of India wanted to apply anything, any article which was left out or any law which had to be applied, it was automatically accepted by state of Jammu and Kashmir and its assembly then and subsequently state governments. So it is very unfathomable that why is it that suddenly overnight you get up and say now. And that's not something which your lordships must appreciate. I've said in my written submissions earlier. In their manifesto, BJP categorically says in 2019, we reiterate our position since the time of Jansang to the abrogation of Article 370. This is the only material with the President of India, nothing else, with greatest respect, in all humility at my command. They wanted to, because Jammu and Kashmir and 370 has become a bone of contention in this country amongst some sections of society. But nobody has understood what 370 is. 370 is not integrating Kashmir into India. And your lordship say again and again in the two judgments, which I will now straight away refer to. I respectfully submit, your lordships must very carefully scrutinize Kaul's case, Premnath Kaul, and Sampath Kumar. Both judgments support my submission on every point. Both answer to what the government of India has said, and they both provide answers to the questions that your lordships have raised from time and again, including on sovereignty. I'll read, just 4 paragraphs from each. PDF page 10 in Premnath Kaul, it's volume 1, it starts at page 7. Just note, don't turn to it, unless your lordships have time, because we are running against time. But this is what your lordships say. PDF page 10, volume 1, page 7, it starts at 10. Clause 8 is very important. It says that nothing in the instrument affects the continuance of Maharaja's sovereignty in and over his state, or save as provided by or under instrument, the exercise of any powers, authority, and rights then enjoyed by him as the ruler of the state, or validity of any law then in force in the state. Then, your lordship say, after the act was enacted by the Yuvraj, my Lord Chief Justice rightly queried, after the act was enacted by Yuvraj, he issued a proclamation on April 20, 1951, directing that Constituent Assembly consisting of representatives of people elected on the basis of adult franchise shall be constituted forthwith for the purpose of framing constitution of a state of Jammu and Kashmir. In accordance with this proclamation, Constituent Assembly was elected and it framed the constitution. Then your lordship says something very important, but it is urged. This is PDF page 16, para 26. But it is urged that sovereignty of Maharaja was considerably affected by provisions of instrument of accession which is signed in October 25. This argument is clearly untenable. It doesn't stop here. Even subsequent proclamation onwards, your lordship say his sovereignty continues to legislate. And your lordships, when your lordships were called upon to decide whether a matter should be referred to a larger bench or not, your lordship said that there is no conflict between Premnath Kaul and Sampath Prakash. Therefore, your lordships declined to refer it. And your lordship said law precedent binds us in that judgment. So, these two judgments, in my respectful submissions, are binding on every point that's been raised. Now, see further. It is true, it is true that by clause 1 of the instrument of accession, His Highness conceded to the authorities mentioned in the said clause the right to exercise in relation to his state such functions as may be vested in them by or under Government of India Act 1935 as in force. Now, Lord, this
No, Mr. Dwivedi, we made it clear that 4 o'clock today we are concluding. Whatever now remains, you can give us submissions and rejoinder. Because even in rejoinder, now we have heard 5 counsel. We have heard Mr. Sibal, Mr. Gopal Subramaniam, Mr. Zafar Shah, Dr. Rajiv Dhawan, and now Mr. Dave is on his legs. So I think 5 council in rejoinder is I think.
Lordship may
broad.
at least give 15 minutes today extra, if possible.
Opinion I had said when we were arguing, cutting down our submissions to argument.
So what we'll do is,
No.
we will,
Instead of half an hour, you stayed reorganized. Half an hour, you were in 2 hours, so you can't say that you want to argue on rejoinder.
what we will do is, we will,
On the state reorganization,
we
the
will,
specific.
we will continue for 15 minutes. We'll wrap up at 4:15. After that, anybody wants to give us anything in writing, not more than 1 page, to just sort of highlight the bullet points.
I would need about 10 to 15 minutes. Now, I'm only on the State Reorganization Act.
With no
Now,
difficulty, but all within 4:15. We have to write it. 4:15 we'll be right.
But some
I'll
latitude, Your
continue.
Lordship.
And
Latitude
4:15.
is 4 to 4:15.
Because the half
So-
day on Monday was taken by the respondent, which Your Lordships had actually apportioned Monday and Tuesday to us.
But then you also took the half day the previous week, you know.
So,
9 days. 9 days
9
to
days.
precise for arguing and opening.
Anyway, no,
1.5 days in rejoinder.
So
let's
what
not
we'll do
complain
now
about
is
time.
what we'll now do is, we'll exactly at 4:15, we will say that we have heard arguments, judgment is reserved. Any further submissions and rejoinder may be submitted within a period of 3 days, not exceeding 1 page for each of the
Conclude,
rejoinders.
I can. I didn't get even 10 minutes. I've been requesting all of them.
We are here till 4:15. After that, this will be the order which will be recorded.
Yes.
That
Don't interrupt,
one page of rejoinder submission.
So, Lord, this is what your Lordship say in paragraph 31, PDF page 17. It's true that by clause 1 of instrument of accession, His Highness conceded to the authorities mentioned in the said clause the right to exercise in relation to his state such functions as may be vested in them by Government of India Act as in force. But this was subject to other terms of the agreement of accession. And clause 6 of the instrument clearly and expressly recorded continuance of sovereignty of His Highness in and over his state. There is no substance in this argument. They rejected the argument on behalf of the petitioner that sovereignty had come to an end. Then, my Lord, your Lordship further said, my Lord, one paragraph.
So we will look at call. Call has been
Yes.
read over.
No, but this is little important because this answers all questions. To my mind, my Lord, respectfully, my Lord, I may say so, will not be at the cost of repetition, that every one of the arguments raised by them stands covered by these 2 judgments. And they have not explained these 2 judgments in their arguments.
Paul and Sampath
Paul and Sampath Kumar. Sampath Prakash.
Yes.
Now, please see. Lord, Article Clause 2. This clause shows, Lord, this is on Clause 3, sorry. Thus, the proviso to Clause 3 also emphasizes the importance which was attached to the final decision of the Constituent Assembly of Kashmir in regard to relevant matters covered by Article 370. This is not PDF page 17, para 31. Then, my Lord, your Lordship say at page para 40, the constitution makers were obviously anxious that the said relationship should finally be determined by Constituent Assembly of the state itself. Please see this, my Lord. Paragraph 40, PDF page 20. Constitution makers were obviously anxious that said relationship should be finally determined by Constituent Assembly of the state itself. That is the main basis for and purport of the temporary provisions made by the present article. And so the effect of its provisions must be confined to the subject matter. The temporary nature, according to your Lordship's, Lord, in Premnath call was till Constituent Assembly, Lord, approved it. It did. President accepted that approval and issued, Lord, presidential order.
Yes.
So, my Lord, this is completely, now, my Lord, neither subsequent proclamation issued by Yuvraj Karan Singh adopting as far as possible proposed constitution, nor constitution order subsequently issued by President purported to impose any limitation on the legislative powers of the ruler. So, my Lord, your Lordships have held that the sovereignty of the ruler continued even after, my Lord, the acceptance of the constitution after Article 1 was applied, after presidential orders were issued. Lord, in Sampat Prakash, your lordships, Lord, have gone a little further and said, Lord, this is what your lordships say. Now, my Lord, in Sampat Prakash, just note this is very important. My Lord, PDF, my Lord, volume 1, page 4, at page 30, page 29-30. My Lord, these very arguments were raised by the petitioner there. The first argument was that article contained temporary provisions which ceased to be effective after Constituent Assembly convened for the purpose of framing Constitution of Jammu and Kashmir had completed its task. Then what are the grounds they give in support of that? They say, my Lord, these special circumstances to which reference was made by him were, one, there had been a war going on within limits of Jammu and Kashmir. There was a ceasefire. That conditions in state were still unusual. That part of the state was still in hands of rebels. And that country was entangled with United Nations in regard to so-and-so. Noting all these arguments, your lordships, my Lord, rejected the argument that it is temporary. Lord, at para 7, at PDF page 30, your lordship says, Lord, very emphatically, there are, however, much stronger reasons for holding that provisions of this article continued in force and remained effective even after the Constituent Assembly of the state had passed the Constitution of the state. Then your lordship say, in fact, no such recommendation was made by the Constituent Assembly of the state, nor was any order made by President declaring that article shall cease to be operative. On the contrary, it appears that Constituent Assembly of the state made a recommendation that article should be operative with one modification to be incorporated in explanation. This modification in article was notified by President by Order 44, laid down that from 17 November article was to be operative. This makes it very clear that the Constituent Assembly of the state did not desire that this article should cease to be operative and in fact expressed its agreement. Please allow me. This article, this makes it clear, Lord, PDF para 7. This makes it very clear that Constituent Assembly of the state did not desire that this article should cease to be operative and in fact expressed its agreement to the continued operation of this article by making a recommendation that it should be operative with this modification only. In view of these provisions, it must be held that Article 370 of the Constitution has never ceased to be operative. What are they arguing, my Lord? Can government of India in the face of law declared by this court under Article 141 say that it has ceased to be operative? Or that it was temporary? Never ceased to be operative, and there can be no challenge on this ground to the validity of orders passed by President in exercise of powers conferred by this article. The argument was that presidential orders are without authority of law because Article 370 has ceased to be operative. They said no. Why? Because they said Constituent Assembly agreed that it should be operative and it was continued thereafter. So what 5 learned judges of this court in both these judgments have categorically held. Now, my Lord, so far as amendment of Article 368 was concerned, as my Lord applied to Jammu and Kashmir, your Lordship said only one thing, that thus Article 368 is not primarily intended for amending the Constitution as applicable in Jammu and Kashmir, but it is for the purpose of carrying out the amendments made in Constitution for rest of India into the Constitution as applied in state of Jammu and Kashmir. Lord, PDF page 33, para 13. So your Lordship went to the extent of saying that those provisions of amending the Constitution There is no time to read anything. So, my lord, your lordships went to the extent of saying that amendment to Article 368 insofar as J&K is concerned is not for the purpose of amending constitution. It is only for the purpose of ensuring that amendments in Constitution of India are effected in Jammu and Kashmir. Expressly, your lordships hold that. These two judgments, therefore, now, my lord, the union has relied on Damnu's case. Lord, Damnu does not, Lord, water down this position at all. Damnu, in fact, my lord, volume 1, PDF page 45 says that necessity of concurrence of the state government or consultation of state government is a must for the purpose of Articles 371A and 1B. And therefore, they said that they place no limitation on Jammu and Kashmir constitution. So, Damnu was an entirely different situation. Now, my lord, as I said, Lord, in my opening arguments, what is the situation? So, my lord, suddenly the British decide to leave. There is a vacuum. By the Independence Act, Lord, they said that now there will be two dominions, Pakistan and India. The territories will be those, Lord, which were part of British India. Subject, of course, to the princely states agreeing to come into India or Pakistan, as the case may be. So, my lord, these accession treaties were entered into. Now, my lord, if that is so, then, my lord, as Berubari expressly holds, if a treaty has been incorporated in the Constitution, 370 is a classic example of incorporation of that treaty. My lord, Clause 6 of the instrument of accession is bodily lifted into 370 in spirit. Now, once it is treaty has been constitutionally recognized, you cannot, my lord, pass any order to undo that. Lord, the whole, what was the purpose? Why were the constitutional framers so conscious of it? Because they wanted to bring about some kind of a resolution which will be permanent in nature. To solidify relationship between Jammu and Kashmir and India. It was not for the purpose of temporarily joining them. They wanted to solidify the relationship of J&K with India. And they realized that the only way we can do it is through the means of Article 370. Because any other way, we would have lost Jammu and Kashmir. So, they were very conscious. Now, can we go behind what they have done or what they have expressly referred to in the article itself? So, Berubari, my lord, expressly holds that if it is a treaty, and if treaty has been recognized by the Constitution, then the only way you can undo it is by amending the Constitution. And Berubari was a case of physical territory. Now, Reorganization Act is a classic example of physical territory of Jammu and Kashmir, which came into India by a treaty, now being subjugated or divided or dismembered into union territories. And you are relying for that purpose a legislative power of parliament to do it. Without amending the constitution under Article 368. Berubari says that you can only follow constitutional amendment under 368 and the strict procedure prescribed thereunder. Nothing else, nothing more. And it defines sovereignty very beautifully. Now, my lord, therefore, my lord, these are, my lord, examples where history, your lordship knows, from 1921, there was a war which went on in Northern Ireland. In 1998, British Parliament had to concede. And the Northern Ireland Legislative Assembly was given away many powers which British Parliament was exercising. Because they wanted permanent peace. Now, my lord, it's not that people of Jammu and Kashmir will die if 370 is not taken away. It's not that. Question is that people have a right to feel that what was understood constitutionally, a constitutional promise, can it be taken away in this manner that has been done? The whole, they are also citizens of India. They are not some foreigners. You are taking away from a sizable section of citizens of India, a special status which was conferred upon them by constitutional framers. Parliament, merely because Parliament has majority, does not have a right to scrap constitution. Constitutions live for eternity. And there is nothing, Lord. Even after 2019, violence has gone on unabated. Every week, Lord, we find people are being killed. Soldiers are dying. You have almost 1 million troops in Kashmir. You travel from Srinagar to Pahalgam or Gulgar, every 100 feet, armed policeman is standing from paramilitary forces. Hundreds of vehicles fly on those roads. So, this argument that there is development and yes, tourism has developed because Kashmir is not the most beautiful place on earth. It's heaven. Anybody who has been to Switzerland will tell us, and Mr. Sibal will tell us because he has seen it much more than I have, that Kashmir is far more beautiful than Switzerland can be. Switzerland is manicured and pedicured.
When we go for official visits, we don't see Switzerland.
So, what I am respectfully submitting, that ultimately people have a right to expect that their status, their rights are respected for longevity. It's a lifetime's promise. It's not a promise for the moment.
Yes.
So, we are seeing, as Dr. Dhawan rightly referred to Israel, what are we seeing today? For 56 weeks, today, 56 weeks, the constitutional amendments taking away powers of the Supreme Court are being resisted by thousands and thousands of people from across the society, civil society, business community, labor unions, lawyers, soldiers, serving soldiers. Everybody is up in arms. Why? Because Constitution is so dear to us. It must remain in our heart. But if constitutional morality is allowed to be tempered with, trifled with in this fashion, then nothing, Mr. Courtmaster. Mr. Courtmaster. Constitutional morality, as Grote says and Dr. Ambedkar quotes him, constitutional morality must be in the heart and bosom of every citizen. Let us not allow union to steamroll so that people lose their love and affection. Now, there is one aspect on federalism that I want to cite from Dr. Ambedkar's debate, which is very important. In his closing remarks, this is what Dr. Ambedkar said brilliantly.
That was read out yesterday. Actually.
No, this part perhaps was missed out. I was hearing it.
Yes.
But there is only one point of constitutional import to which I propose to make a reference. A serious complaint is made on the ground that there is too much of centralization and that the states have been reduced to municipalities.
It was read.
Yes. Now, this aspect is very important because he calls basic principle of federalism is that legislative and executive authority is partitioned between center and states, not by law.
Yes.
Now, if Constitution has conferred this special status, then I respectfully submit.
This is volume 8, page 5 and volume 8, page 1299. Mr. Giri, you read out this extensive.
Now, Mr. Giri read also the aspect of whether democracy will be lost. Dr. Ambedkar says further, which he certainly didn't read. Democratic system India lost. Will she lose it a second time? I do not know. But it's quite possible in a country like India where democracy... This was not read. I was sitting. From its long disuse must be regarded as something quite new. There is danger of democracy giving place to dictatorship. It's quite possible for this newborn democracy to retain its form, but give place to dictatorship. In fact, if there is a landslide the danger of second possibility becoming actuality is much greater. Happened in 75. It happened in 1975. We cannot, my lord, these are not, Dr. Ambedkar's every word, my lord, in the opening and the closing speech is not, it must be written in golden letters by us. It should be in our heart. We cannot, my lord, overlook the fact that, my lord, ultimately, my lord, as Burke says and Ambedkar quotes him, that you can't rule by force all the time. And if you have to rule by force, then there is no governance at all. So I respectfully submit that your lordships may, my lord, kindly accept the interpretation that, my lord, we are canvassing, that 370 is permanent in nature and that sub-article 3 was temporary in nature. That power was exercised, it was exhausted. And, my lord, in place of Constituent Assembly, it's a fraud on Constitution, my lord. To say that now, my lord, Legislative Assembly, Governor, President, Parliament, everybody can exercise powers in respect thereof. How do you, my lord, ascribe? It's doing violence to the plain language of the constitutional framers. And that, in my respectful submission, my lord, your lordship's court have never permitted. Ultimately, it's your lordship's court which has always upheld rule of law. So, my lord, I respectfully submit that these writ petitions deserve to be allowed and the orders deserve to be submitted.
All other submissions may be filed not more than 1 page, at the most 2 pages.
My lord, only one request.
Just one thing, one second. Look, your lordships had told me to curtail my argument because your lordship said I want to call on them with regard to the state reorganization. I need to put in a substantial rejoinder. 150-page written submissions are put in and arguments are made, lords, which are completely contrary to the facts. Your lordships were told by the solicitor that Mr. Singh has kept from you the Jammu and Kashmir Reorganization Act. Had he shown your lordship the act, you would have seen that nothing has changed. Everything is there. I need to put in so I will put in, please don't hold me down to 1 page. I appreciate that your lordships don't want to sit tomorrow, but I must at least some latitude about 4 or 5 pages in rejoinder. I'll put in a brief note. I will not repeat anything, but I will deal with it. Otherwise, this whole aspect that I was the only one who addressed your lordship.
Do that in 2 pages, Mr. Singh,
My lord,
because now we have heard arguments. We can confine it to 2 pages, the bullet points you can pull at.
Deal with the submission. The solicitor solemnly tells your lordship certain things which are contrary to the fact, but he told your lordship that the act, and he handed up copies of the act. He said, had you been shown the act, Mr. Singh has made a big deal about Article 246, this, that, but nothing has changed. Everything is given to
That will lead to multiple responses from this side and that side. Go on.
You're not sitting is one thing.
Therefore, Mr. Singh, now 2 pages you can certainly give us. 2 pages. I think you can imagine if we give you 5 pages, there will be at least 10 to 12 counsel who would want to file. We'll have another 60 pages to, and then they will say we will file submission for another 60 pages. So that.
Your lordships had.
So what we'll do is,
July we were frozen, we stuck to it.
Mr. Sipal was.
Stick to it. They filed 250 pages worth of submissions are filed by one person.
But volume is not always equivalent to something that you have to read every
Question of fact.
or respond to everything. There's sometimes there are charts, there are other things, and
I'm only on the state reorganization. I mean, some latitude.
Manoj, on behalf of Mr. Nafe also. Manoj, on behalf of Mr. Nafe also.
Mr. Sibal was to share the affidavit, my lord. No, we would like to see, my lord. Yes, we have not received the copy.
Manoj, I had on behalf of Mr. Nafe also, Article 368 argument for amendment.
Everybody has argued the same thing with respect, again and again.
368, Manoj, not the amendment.
The affidavit.
Manoj, there's a different view on amendment to 368, so just 2 pages. Just within 2 pages for my submission.
Only a minute, Mr. My lord, it says, I am a responsible and dutiful citizen. I have exercised my right to approach this court. I reiterate the oath taken while being sworn in as a member of parliament.
Preserve and uphold the provisions of the Constitution of India and to protect the territorial integrity of India.
But this is not rebuttal, but this is adding insult to injury to the nation.
We'll analyze what is there in the.
Kindly, my lord, say something about it, I leave it at that. Your
One of the
lordship
requests for
have,
3 pages. One of the requests for
Well,
3.
we must end it with a vote
That's
of thanks
correct,
to all the, all
Your
the members of the
lordships
bar.
may-
Thank you very
Your
much.
lordships may read what is not written. Your lordships may read what is not written.
Thank you, Lordship.
Thank you very much.
And thanks to nodal council also. Nodal council, they have done a great job.